Hello, everybody. My name is Kristen Dodson. I am going to share with you about the riveting topic of HIPAA privacy considerations. So this is a huge topic with a lot of information. So I've attached links to the handout for you to access more detailed information, and just really hope you guys have a good time with that because this is just some really good stuff here. Okay, so what is the HIPAA privacy rule? The HIPAA privacy rule establishes national standards to protect an individual's medical records and other personal health information, or PHI. Its purpose is to define and limit circumstances in which an individual's PHI may be used or disclosed. So protected information includes individually identifiable health information held or transmitted by a covered entity. An individual's past, present, future, physical or mental health or condition is protected. Other identifiable health information is like the provision of health care. Past, present, or future payment for the provision of health care is also protected under this, as well as demographic identifiers like name, address, social security number, etc. The privacy rule recognizes that circumstances arise where health information may need to be shared to ensure the patient receives the best treatment. The goal of the rule is to strike a balance that permits important use of information while protecting individuals' privacy. In sharing, its central principle is of sharing the minimum necessary. Keep that in mind, minimum necessary, which means disclosing the minimum amount of personal health information needed to accomplish the intended purpose. So they want you to disclose as very little to kind of as is needed. Okay, so who is covered by the privacy rule? The privacy rule covers health plans, healthcare clearinghouses, and any healthcare provider who transmits health information in electronic form, so business associates, etc. These are all referred to as covered entities in the rule. So entities may not use or disclose PHI except as the privacy rule permits or requires, or as the individual authorizes. The privacy rule requires each covered entity to provide a notice of privacy practices that contain the following: a description of the ways in which the PHI may be used and disclosed, the entity's duty to protect privacy, provide notice of privacy practices, and abide by the terms in the notice, a description of the individual's rights, including right to complain to HHS, which is Health and Human Services, and the covered entity if privacy rights are believed to have been violated by the individual or the patient. And it must include a point of contact for further information and making complaints to the covered entity. So those are all required in the Notice of Privacy Practices underneath the privacy rule. Okay. Authorization must be obtained for any use or disclosure of PHI that is not treatment, payment, or healthcare operations or otherwise permitted by privacy rule. Authorization must be written in specific terms and in plain language, so not all confusing and jumbly where people can't understand what the heck you're talking about. Okay, generally, the privacy rule applies to all protected health information with one exception: psychotherapy notes. That's where it gets real for us, guys. Psychotherapy notes receive special protections because they contain sensitive information and are the personal notes of the therapist, typically not useful for treatment, payment, or healthcare operations. Okay, so privacy rule defines those notes as those recorded by a healthcare provider who is a mental health professional, us, documenting or analyzing the contents of a conversation during a private counseling session or a group, joint, or family counseling session, and that are separate from the rest of the family's medical records. So they are separate from the medical record. With a few exceptions, the privacy rule requires a covered entity to obtain a patient's authorization prior to a disclosure of psychotherapy notes for any reason, including disclosure for treatment purposes to a healthcare provider who is not the originator of the notes. So already you can kind of see that there are some extra protections around psychotherapy notes, and this is one of them. That there are very few exceptions to obtaining a patient's authorization prior to disclosure. So these are important things. Some exceptions are, some exceptions for obtaining authorization are mandatory reporting of abuse, mandatory duty to warn regarding threats of serious and imminent harm made by the patient, although state laws vary, take note, to defend itself, or there's not an exception for obtaining an authorization to disclose information, or if a covered entity is defending itself in legal proceedings. For Health and Human Services investigation of compliance with privacy rules, apparently, according to this rule, you do not need to obtain authorization. Where there is a serious and imminent threat to public health or safety, or lawful activities of a coroner or medical examiner as required by law. Does not require authorization. Okay. Or is an exception to obtaining authorization. Okay. Covered entities who originated the notes may use them without authorization for treatment and its own training. So if a little place has originated notes, they're the originator, they can use them for training and treatment and training underneath its own little umbrella, I guess. Okay, the HIPAA privacy rule addresses questions around when it is appropriate under the privacy rule for a healthcare provider to share the protected health information of a patient who is being treated for mental health conditions. The privacy, and here are a couple of those. The privacy rule clarifies when HIPAA permits healthcare providers to communicate with a patient's family members, friends, or others involved in the patient's care. It clarifies when HIPAA permits healthcare providers to communicate with family members of an adult patient or with parents of a minor. The privacy rule considers the patient's capacity to agree or object to the sharing of their information. In the case that a patient is incapacitated, the privacy rule permits a healthcare provider to determine if disclosing a patient's information is in their best interest. It also defines what is incapacitated and what to do in those things. So these are very just short little blips, guys. I would suggest looking at the links. The privacy rule clarifies when to involve family members, friends, or others in dealing with a patient's failure to adhere to medication or therapy. Here's a little hint. It's when the patient is believed to be present or believed to present a threat to the health or safety of themselves or others, as is usually when we kind of are okayed to step in. And it is reasonable that the others involved may reasonably be able to prevent or lessen the threat. So there's a lot of reasonable in there, because a lot of times, and a lot of throughout this privacy rule, it relies pretty heavily on a provider's best judgment. So, I don't know. Okay. The rule clarifies when it is appropriate to listen to family members about loved ones receiving mental health treatment and consider their shared information in the treatment plan. The privacy rule clarifies when it is appropriate to communicate with family members, law enforcement, or others when the patient presents a serious and imminent threat of harm to self or others. And finally, it clarifies when HIPAA allows providers to communicate to law enforcement about the release of a patient brought in for an emergency psychiatric hold. So, as you can see, the privacy rule is extensive. And I've only given like a teensy little glimpse into what is included and given just like a couple of little blips about some privacy considerations that it covers. So I hope that you will take a minute to peek at those links that I've posted.